Think your business is too small or too far away to worry about EU data rules? Think again. GDPR reaches globally, and ignoring it could cost you millions. First, a disclaimer. This video is for informational purposes only and does not constitute legal advice. If you would like personalized guidance, you can contact our team or another qualified professional. Hey everyone, Robert here, legal consultant, licensed tax advisor and founder of Extraterritorial Consulting based in beautiful Slovenia. We've helped companies worldwide navigate GDPR without facing those eye-watering fines. Today, we're tackling a big question. Why does GDPR apply and who exactly must comply? Get this wrong and you're at risk. Get it right and you build trust effortlessly. Ever wondered how an old 1995 law got upgraded for today's cloud and tracking world? GDPR is that upgrade, protecting personal data while setting global standards. Let's break down the timeline, scope, who it hits, and key duties. First, the GDPR timeline. The GDPR was adopted in April 2016. It entered into force in May 2016, but companies got a 2-year grace period to prepare. In May 2018, it became fully applicable. Rules enforced, fines possible. Why the delay? To let businesses review policies, train teams, and upgrade systems. Since then, GDPR's extraterritorial reach has made it a worldwide benchmark. Up next, the scope of GDPR. In one sentence, it covers processing of personal data. But this doesn't tell you a lot, right? Therefore, before we proceed, we must define the two key terms, which are, firstly, what is personal data under GDPR, and secondly, what is processing under the GDPR. First, let's start with personal data. In accordance with the GDPR, personal data is any information that can directly or indirectly, alone or in combination with other information, identify someone, a natural person of course. Examples of personal data are names, emails, IP addresses, location, and other similar data. Now for the processing part. In accordance with GDPR, processing means collecting, storing, using, transferring, recording, making it available, adapting, altering, or even deleting the personal data. The next question we need to answer is, who does GDPR apply to? The GDPR applies to EU-based organizations, but also non-EU companies if they offer goods or services to EU residents or monitor their behavior, like tracking website visitors. Therefore, if you are selling online to Europeans or using cookies for analytics, GDPR likely applies to you even if you are incorporated outside the EU. This extraterritorial scope closes old loopholes, keeping EU data safe globally. Now, who must comply? Main roles in GDPR are controllers and processors of personal data. A controller decides why and how data is processed, like a shop using customer emails for marketing. A processor, on the other hand, handles that data in accordance with the controller's instructions, like a cloud storage provider, for example. Both bear obligations, no exemptions for size or sector. This includes businesses, non-profits, public bodies, you name it. What about non-EU firms? Yes, it also applies to them if they are targeting or monitoring EU residents. Here are some tips to figure out your role. If you are the one who decides the purposes and means of data processing, you're a controller. If you are just processing the data in accordance with instructions, you're a processor, but still responsible nevertheless. Make sure you clarify these roles in contracts for shared duties. And remember, everyone in the chain shares accountability. Finally, what are the core obligations? Built on Chapter 2 principles of the GDPR, process personal data lawfully with correct basis, fairly and transparently for specific purposes only. Minimize data collected, keep accurate records of processing, and limit the time of processing. Make sure the personal data you process is secure and prove your compliance. If you are processing personal data at a large scale, sensitive personal data, or doing public processing, you must appoint a data protection officer. Let's say you did everything right, but a data breach, hack if you will, still happens. What do? Notify your national competent authority within 72 hours with details and fixes. If individuals are seriously affected, you must also notify them. Up next, the GDPR wants to level the playing field by offering extensive rights to individuals, which you, as a controller or processor, must comply with. These rights are right to be informed, right of access, right to rectify, right to erase or right to be forgotten, right to restrict processing, right to portability, right to object, and right to oppose automated decision-making. A bonus right is an individual's right to lodge a complaint with the local authority if you do not comply or they do not agree with your verdict. Respond to the individual's requests promptly. Here are some practical steps. Audit data flows regularly. Use encryption and controls. Train staff on what to do in cases of data breaches. And base processing on valid grounds that you can prove. To recap, GDPR kicked in fully in 2018 after a prep period. It covers personal data processing worldwide if linked to EU residents. Controllers and processors all sizes must follow principles, appoint DPOs when needed, report breaches fast, and honor individuals' rights. In 2025, ongoing discussions aim to ease record keeping for smaller entities, but core rules stay strong. If you do not comply, there will be fines, damages, and a loss of trust coming your way. But if you comply proactively, you gain customer loyalty and competitive edge. Understanding when and who GDPR obliges turns a potential headache into a smart business practice. Stay ahead, protect data, and most importantly, protect your future. If this cleared things up, hit like, share with your team, and subscribe for more straightforward compliance guides. Explore our knowledge center for deeper dives, the link is below. Thanks for watching, and remember, compliance with the law prevents the flaw. Till next time.